Okay, back on the record. Let's see.
We could, Your Honor, I just briefly, and this is gonna be done before the jury comes in. I've informed Mr. Limas, what I was gonna tell you is if necessary, my one rebuttal witness is Detective Osborne. She had an interview scheduled. She was over at the ops center. I've let her know that she may need to be here. I've texted her prior to restarting here. I'm just not sure if she will be here at that time, but it's only like a 10-minute drive, so
Sounds good.
if necessary.
Also, I can't find jury instruction 7.40. I probably should have got the file. I think, Mr. Lee, you requested 7.40, and I don't see that. It's jury instruction anyway. You all can rise. First of all, if the judge is standing, you're supposed to stand. Second of all, the jury's coming back.
Yeah, the question to that person. I was like, I definitely need to get back to you.
Jury instructions. Okay, you can be seated. Thank you for being so prompt. And we're going to proceed with defense witnesses. Mr. Lee, you can call your next witness or your first witness.
Thank you, Your Honor. Defense calls Nevaeh Lino Limas.
Just gonna stop right here and then raise your right hand. Yes, ma'am. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can have a seat. Right in front of you is a microphone, and the lady behind you is my court recorder. Her job is to take down everything being stated in the courtroom, so your responses must be loud and clear. You have a light voice, so try to speak up a little louder, okay? Okay, try again, louder than that.
Okay.
Thank you. Just make sure make sure the clock can hear you. Say it loud again. Say okay.
Okay.
Thank you. And then if there's an objection from either party, you're gonna stop responding. I'll give a ruling on that objection and I'll tell you if you can give us that answer or not. Lastly, all of your responses should be verbal, no mhm and ahs, or head nods and head shakes. Otherwise, you're gonna hear us ask you, is that a yes or a no, okay? Okay, state your first and last name and spell both.
Nevaeh Melissa Lino Limas, Nevaeh, Melissa Melissa. My last name is Lino-Limas.
You can proceed.
Thank you, Your Honor. Ms. Lino Limas, thank you for appearing today. On or about April 19th, 2022, were you at a place commonly known as the Mexican store?
Yes, I'm.
Okay. And while you were there, was there an incident?
Yes.
And did that incident involve both you and Sunshine Wheatley?
Yes, we do.
And who drove you to the store that day?
Christina Trevino.
Christina Trevino drove you to the store that day. And um, this incident was an altercation. Um, Did you see how Miss Wheatley injured her arm or her finger in this
She
altercation?
fell in a pothole.
She fell in a pothole, and that's how she injured her finger?
Yes.
I see. Was your mother there? Was Lorandi there?
No.
Does anybody in your family own or drive a blue Chevy Traverse?
No, sir.
No further questions.
Cross-examination.
Good afternoon. So you stated that on about April 19th, 2022, you were at the Mexican store, correct?
Yes, sir.
Okay. And why were you at that location?
I was there with my son's mother, Christina Trevino. We were going to go get something to make breakfast or lunch. Whatever.
And what happened when did you encounter Miss Sunshine Wheatley there?
Yes, I see.
And what happened when you encountered her?
We had some back and forth comments, and then we had an altercation.
And who started that altercation?
It was kind of both, I guess you could say.
Did you drag Miss Wheatley out of her car by her hair?
After she put her hands on me, yes, I did.
So she was in her car and she put her hands on you? Can you
No,
explain?
she had her car door open and she got out and she was saying whatever she had to say to me. And then she started walking up to me and putting her fingers and stuff in my face. And that's where the altercation started.
But you just stated on the record that you pulled her out of her car by her hair.
Yeah,
Did
that's
you?
after she was walking back to the vehicle and she was in her vehicle.
So the altercation had ended at that time, and then you continued it by dragging her out of her car by her hair.
That's because she put her hands on me.
And then you stated that she broke it falling in a pothole.
Yes, yes,
Okay. Did you see that happen?
yes.
Okay. And do you know that broke her finger?
Well, she landed on her hand and her leg when she fell in the pothole.
But do you know for a fact that that's what broke her finger?
Yes.
And how do you know
There was no other
that?
way that she could have broke her finger or her anything.
And did you ever, so when this case began against your mother, did you ever notify anybody that your mother wasn't there?
Yes.
And who did you tell?
I'm going through the same thing. So it was when she came about and came to you guys, she specifically said that it was me that did that to her. And then somehow she got my mom involved and my mom was never there.
When you say she, who do you?
Sunshine Wheatley.
Okay, but so you're saying that Miss Wheatley just out of nowhere accused your mother of this, correct?
Correct.
Okay, but did you ever go to anybody, the police, her attorney, Mr. Lee, anybody stating that, no, she wasn't there?
Not to my mom, but to my attorney, yes. With my situation. It happened 2 years ago and she's just now saying something or telling you guys about the situation.
No other questions at this time, Your Honor.
Redirect.
Thank you. To be clear, when you were asked about who was there, by whomever asked you, you told them that who was there, and that list did not include your mother, right?
Yes, sir.
Okay, thank
Any questions from the jury for this witness? Okay, may this witness be excused?
Yes, sir.
Okay, there's a sequestration order, ma'am, so that means you can't discuss any portions of your testimony with any other witness, okay?
Yes, ma'am.
You can be excused. Any other witnesses?
Correct.
Do you have any other witnesses?
Yes, Your Honor, we'd like to call Mr. Dwayne Dodge.
Where is he? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
You can have a seat, sir. Okay, in front of you is a microphone, and the lady behind you has to take down everything that's being stated in the courtroom, so your responses must be verbal and loud and clear, okay?
Yes,
Okay, so are you doing good? No head nods or head shakes, no mhm, uh-huhs. Yes or no to yes or no questions is what we need so we can understand it in the record. If there is an objection from the attorneys, you would stop speaking. I'll give a ruling on that objection for the attorneys, and then I'll let you know if you can get that answer or not, okay?
yes.
State your first and last name and spell both.
First name Dwayne, last name Dodge, Duane Dodge.
Okay, you can proceed, counsel.
Thank you. Mr. Dodge, thank you for being here today. We have been discussing an incident that happened on or about April 19th, 2022. Does that date or that time period stand out to you for any reason?
Yeah, I had severe surgery to my right foot.
You had a severe surgery to your right foot. What specifically was done to your right foot?
I guess the first toe from my big toe on my right foot was amputated.
Okay, so you had a toe amputated.
Yeah.
Okay. And so when you came home from the hospital after having this surgery, did you need help with anything?
Yes, I did for quite some time.
Okay. And what types of things did you need help with?
To get around a little bit, I couldn't use the second floor bathroom, so I had to be walked over to the commode that was brought to the home.
Gotcha.
Water, food, just the little things you take for granted in life I couldn't do anymore.
Gotcha.
And so I needed care.
Okay. And did your daughter, Lorandi, help provide that care for you?
She did, yes, sir.
Okay. And who else helped provide that care?
My wife.
Your wife. So your wife and Lorandi were helping you out after you got home from surgery. What did that look like? Who was there during the day? Who was there at night?
My wife worked the second shift, and she still does to this day. Randy was open to help me. They're both kind of in the medical field, so that was helpful to me. So during the day, Randy would help me out. And then my wife sometimes would pop in around 11:30, sometimes 1. She'd work a little bit over, do her paperwork, and then they would relieve each other after dark. After when my wife came home.
So during the day, Lorandi was at your house helping care for you.
Yes. Yes.
And so on the date in question, is that where she was?
Yeah, she was with me. She was, as far as, yeah, I couldn't do anything at all without being helped.
Gotcha. Thank you very much. Appreciate it.
Yes.
Cross-examination.
Yes, just briefly. Good afternoon, Mr. Dodge. So, Mr. Dodge, you claim that on April 19th, 2022, Miss Lorandi Limas was helping you out of your house, correct?
Yeah.
Okay. And did you ever, when you were made aware of this criminal charge, did you ever come forward to anybody about that?
No, I was kind of in the dark about the whole thing. I really wasn't thinking about it. I was thinking about the healing process with my foot. I wasn't actually brought into it till later on. But then even at that time, I was just like, wow, I just can't believe this is happening. You know what I mean?
Okay. And then when you were made aware, so when would you roughly estimate about when you became aware of this criminal matter?
It was quite some time. I mean, I can't be exact, like weeks or months, but it was brought to my attention.
Okay, and at that time, did you come forward to anybody that she was with you?
No,
Okay. Is there any particular reason you didn't come forward, or?
yeah, I just felt there wasn't. I mean, she was with me. I mean, I couldn't. There's no other way to explain it to anybody else.
Were you ever contacted by a Detective Kasha Osborne from the Lansing Police Department?
Yeah, yep.
Okay. And why were you contacted by Detective Osborne?
She asked me, was I there? And I was like, there? Like where? And she kept, demanding I was there at whatever was supposedly had happened. So they say happened with her and the Sunshine Girl.
Okay. And at any point, so you actually had a conversation with Detective Osborne?
No,
Okay. Can you briefly describe what was your interaction with Detective Osborne then?
she said she wanted me to get back with her on that, but to me, there was no reason for me to contact her back because I wasn't there. There was no reason for me to. I figured she knew that, whatever they knew. I wasn't there. I was laid up in bed.
I understand, sir. I understand you were laid up in bed, but if your daughter was there with you on the date that she's being accused of committing a crime,
Right.
isn't that something that you think would be important for the police to know?
At the time, I just didn't. To me, it was just like I thought it would just go away. To me, it was just maybe something would just pass because it wasn't true. I didn't know it would, end up at this level, at this courtroom today.
And after Detective Osborne initially contacted you, did she ever try to contact you again?
I think she tried to contact my wife. My wife was asking, I just want me to contact you saying we were there. And we were like, where? Where were we? We were nowhere.
Okay. So, in your estimation, if your daughter was not at this incident, and maybe this is just reactive, but wouldn't that have been something that would have been important for the police to know so that we would not have gotten to this level?
I mean, it wasn't coming at me like that, like at that level. You know what I mean? And I had stuff, on my mind as far as healing, trying to get back to work to provide for my family. So I wasn't really. It just didn't seem real to me. Like maybe this would just pass. You know what I mean?
Okay.
So I just didn't really take it like that serious.
No other questions, Your Honor.
Can you redirect?
Thank you. Just to be clear, Mr. Dodge, how long ago was it that the detective tried to contact you?
I want to say now maybe a little over a month. It's been a while.
Okay, so a little over a month ago, or approximately a year and a half after the incident happened.
Yeah.
Did anybody from the police ever contact you before that?
No.
No further
No.
questions.
Thank you.
No.
So there's a sequestration order. So that means that you cannot discuss your testimony or portions of your testimony with any other witness, okay? Sir?
Yes.
Okay.
I'm sorry.
You can be excused
Thank you.
unless the jury has a question for you. Okay, thank you. Any other witnesses?
No other witnesses.
You got a witness?
Yes, Your Honor, if I can be granted just a minute to see if she is present or to see where she is at.
If she's not here, she's not here.
Give me just 1 second.
Thank you.
Detective Osborne's not here at this time, Your Honor. However, the people would request a brief recess in order to get in touch with Detective Osborne to get her here. I have been in touch with Detective Osborne all day, Your Honor.
Today's the date and time set for a jury trial. Detective Osborne was subpoenaed to be here. She's supposed to be here. If your witness is not available, we need to proceed.
All right, thank you, Your Honor.
Any other witnesses you intend to call?
The people, Your Honor.
Nothing for the defense.
Okay, closing argument.
Just one second, Your Honor. Good afternoon, ladies and gentlemen. We're here today, as I stated before, because the defendant, Ms. Limas, has been accused and charged with the crime of aggravated assault. I asked you in my opening statement to consider the elements of aggravated assault and use those sort of as a checklist. I would also ask that as you go through that, to remember the testimony we heard here today. We heard testimony today from the victim, Ms. Sunshine Wheatley, and from her boyfriend, Mr. Damari Watley, my apologies. We heard testimony from both of them that they were at what is commonly known as the Mexican store here in Lansing in Ingham County on the date of April 19th, 2022. On that date, they ran into the defendant, Ms. Limas, her daughter, Ms. Nevaeh Lino Limas, and we heard testimony. There was another individual, a Ms. Alexis Mejia. We heard testimony from both of them that while they were there, an assault occurred, an assault that was begun by Ms. Nevaeh Lino Limas dragging Ms. Sunshine Wheatley out of the car by her hair and proceeding to assault her. We also heard testimony from both Ms. Wheatley and Mr. Watley that Mr. Watley attempted to step in and shield his girlfriend from the assault, and that during the assault, the defendant, who was identified both by sight and by voice, by sight by Mr. Watley and by voice by Ms. Wheatley, appeared with a handgun, stating out loud something to the effect of, "I have a gun." I believe there was also something about "don't touch her, she's underage, I have a gun," I believe was the quote that Mr. Watley testified to. We then also heard testimony from the victim, Ms. Sunshine Wheatley, that as she was on the ground, head down, eyes in the pavement, being assaulted, she felt a metallic object strike her in the hand. We also heard testimony from Ms. Wheatley that during this assault, nobody else had any other metallic objects. The only metallic object that we have evidence of here today was said firearm. We did hear testimony from defense witnesses who claimed that Ms. Limas wasn't even there. However, when asked on cross-examination, neither of them bothered to inform the police. Neither of them bothered to inform her attorney, Mr. Lee. If they had, there would be no even need to have this trial here today, because we would have that evidence. But I submit to you that Ms. Limas was there that day. I submit to you that these two witnesses are not credible witnesses, and that Ms. Limas did intend to injure Ms. Sunshine Wheatley and swung a firearm at her, hitting her in the hand and breaking her finger. We heard testimony that Mr. Dodge was contacted by LPD about this incident a month ago. This incident happened, as we have said many times, ladies and gentlemen, on April 19th, 2022. Yet, he felt there was no need to come forward with any sort of alibi. I find that highly suspect. We did hear testimony, as I stated, though, from Ms. Wheatley and Mr. Watley that was highly consistent. With that, ladies and gentlemen, I would ask you to come back with a verdict of guilty.
Mr. Lee.
Thank you, Your Honor. Ladies and gentlemen of the jury, I'm going to start with the last thing the prosecutor said. He said you heard them tell stories that were entirely consistent. It's not what I heard. I heard a lot of inconsistencies. I heard Miss Wheatley say to the police, "This whole incident happened over at the 7th Avenue Park, right next to my aunt's house." But then she came into court today and said, no, it happened at the Mexican store. Well, what happened between the time she spoke to the police and today? I'll tell you what happened. Mr. Watley, when he talked to a detective who gave his testimony, went back and told her what his testimony was. And they said, we better get our stories straight. but they still couldn't, because he came in here, and after she testified, Nevaeh and Alexis were fighting me. He came in here and didn't even mention Alexis. I had to show him to where he had already said Alexis was there for him to go, oh yeah, right. Alexis was there too. Because he had it so set in his mind that he was out to get LaRandy that he forgot to tell the truth. Don't trust that man. Don't trust anything he says. Okay. And Miss Wheatley's story changed several times. We talk about the identification of Miss Limas. How do we know she was there? Well, Miss Wheatley said she heard. Okay, maybe she could tell her voice in that moment while being pummeled by two people and all the adrenaline. Maybe she could tell a woman's voice and make it distinct. Maybe. Mr. Watley said he saw her, but he had never seen her before. And so we're supposed to believe now that because he comes and points to the person at the defense table, that he knew exactly who it was. Nevaeh point blank said she wasn't there. Christina Trevino drove her up to that market. So do we really believe that Mr. Watley could even identify the defendant? I'll tell you what he did say that was significant. He said, and I quote, I never saw LaRandy swing the gun or strike anybody. The whole ball of wax here is, did you swing a gun and strike somebody on the hand and break their finger? Well, you got one person who says, I couldn't see anything, and another person who says, I saw everything and I never saw her swing her gun and hit anybody. So again, the prosecutor's right. How did we get here? This is just ridiculous, beyond a reasonable doubt. Remember, we talked about that at the beginning, beyond a reasonable doubt. This is so far from beyond a reasonable doubt, it's ridiculous. And she does have an alibi. She was helping her father. She wasn't there. They can try to pick that apart all they want. I got a question for the prosecutor. Why didn't the police ever talk to my client? Why did they wait till I called him as an alibi witness to send a detective to talk to him? Why were they so uninterested in the complete story and so in a hurry to drag us into court and put a solid citizen on trial in front of everybody? This is the definition of reasonable doubt. There is no choice. You have to come back with a not guilty verdict. You have to. They have not met their burden. So I thank you all for being here. I appreciate your time.
Okay, Fred.
Just to clarify a couple of things that Mr. Lee said. He'd like you to believe that Miss Wheatley's story changed from when she talked to the police to now. But what I heard in the clip is that when she testified, when she testified here on the stand today, she said that the store they were at was over on US 27, is what it was. If you listen to what she says on the tape, after she finishes describing location, she says, I believe what she said was, it was around the corner from her aunt's house, and I heard her say on Old 27. So I would submit to you that her story has not changed, and that perhaps when writing the original report, the officer did not write it right. We also heard he would like you to believe that it was only after that they came forward as alibi witnesses that the police interviewed them. And while yes, that's true, why did they not come forward beforehand, ladies and gentlemen? This case probably shouldn't, if their story is true, this case should not even have gotten to that point. I submit that their story is not true. If this Miss Trevino was the one who drove them to the store on that date, why did we not hear testimony from her? We only heard it from Miss Limas's daughter. Ladies and gentlemen, I would submit to you that having heard all the evidence, let me back up a second. We also heard in Mr. Lee's closing that, yes, Mr. Watley testified he never saw her swing the gun, but we also saw Mr. Watley testify through example that he was trying to shield Miss Wheatley from the attack, and he was facing down as well. The testimony we have from the victim in this matter, Miss Wheatley, was that she felt a metallic object strike her hand, causing it, and then when it struck her hand, she felt it pop and she felt the bone break. That is the testimony and the evidence we have here today. She also testified that nobody else had a metallic object during this assault. I submit to you, ladies and gentlemen, that the defendant, Miss Limas, was there on that day. She did have a firearm. She intended to assault someone with it. She did assault Miss Sunshine Wheatley with it, and she caused the breaking of Miss Sunshine Wheatley's finger to the point where she, I believe, testified she had to have pins and rods put in it. With that testimony, ladies and gentlemen, I would ask you to come back with a verdict. Thank you.
Well, with that, ladies and gentlemen of the jury, that concludes our proofs and arguments. We're going to take a brief recess so that we can review some final instructions. You're not free to deliberate just yet, but you're going to have a short break, and then I'll bring you back here, go over your final instructions, and then you'll be able to deliberate at that time. All right, all rise for the jury. What is this? You can be seated. Okay, one of these multiple questions on here, I assume these are questions. One is to see the pics again, which they can see the pics. And then one just says doc appointment. I don't know what that. But nonetheless, there's no witness for them to ask the questions of. And I asked them before the witness left if they had a question. So Okay, very good. You can be seated. Okay, and jury number 3, when you were exiting, you did provide us a sheet with some, I believe one of these was supposed to be a question. I don't know if these were notes or you had a question about one of them. I do see something about CPICs again, and once you are able to deliberate, we can provide those to you at that time. The other questions, I'm not sure who they were posed to, but I asked those, did anybody from the jury have a question while the witnesses were here under oath? And so they're no longer here to answer those questions. And at least the one that's written in blue, that's actually not relevant. So we wouldn't have asked that question anyways, okay? Thank you. Okay, and so for final instructions, if you want to turn your attention to the screen to the extent that it wants to work while we do this, we will go over our final instructions. Okay, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see to it that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of facts, and you should decide this case from the evidence. At times during the trial, I have concluded or excluded evidence that was offered or stricken testimony that was heard. Don't think we did that today. But do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 19, 2022, within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your verdict must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes, my instructions, and if you want to look at any of the reference documents or exhibits that have been admitted, just ask for them. I'm going to go ahead and put the one exhibit in the book with the instructions. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing those possible verdicts. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. When the lawyers agree on a statement of facts, these are called stipulated facts. We didn't have any stipulated facts, so I'm going to skip that. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Again, the elements of the charge of aggravated assault. The defendant was charged with the crime of aggravated assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that the defendant intended to injure Sunshine Wheatley or intended to make Sunshine Wheatley reasonably fear an immediate battery. Third, that the assault caused a serious or aggravated injury. A serious or aggravated injury is a physical injury that requires immediate medical treatment or that causes disfigurement, impairment of health, or impairment of a part of the body. And the defense is asserting an alibi of lack of presence. You have heard evidence that the defendant could not have committed the alleged crime because she was somewhere else when the crime was committed. The prosecutor must prove beyond a reasonable doubt that the defendant was actually there when the alleged crime was committed. The defendant does not have to prove she was somewhere else. If, after carefully considering all the evidence, you have a reasonable doubt about whether the defendant was actually present when the alleged crime was committed, you must find her not guilty. In the alternative, the defense is putting forth a self-defense argument. The defendant claims that she acted in lawful self-defense of Nevaeh Lino Limas. A person has the right to use force to defend another person, in this case, under certain circumstances. If a person acts in lawful self-defense of others, her actions are justified and she is not guilty of, in this case, the crime of aggravated assault. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense of Nevaeh Lino Limas. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time that she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect Nevaeh Lino Limas from the imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend Nevaeh Lino Limas, even if it turns out later she was wrong about how much danger Nevaeh Lino Limas was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect the other person from danger. The defendant must have used the kind of force that was appropriate to the attack made and the circumstances as she saw them. When you decide whether the force used was what was necessary, you should consider whether the defendant knew about any other ways of protecting Nevaeh Lino Limas, but you may also consider how the excitement of the moment affected the choice the defendant made. Third, the defendant or the right to defend another person only lasts as long as it seems necessary for the purpose of protection. What just happened there? Okay. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that would not prevent her from claiming self-defense if she was attacked. Lastly, the burden of proof for self-defense. The defendant does not have to prove that she acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. And that concludes our jury instructions. You are going to be free to take your notes with you. I have a copy of jury instructions. You should first pick your foreperson, and then you all will be free to deliberate. Let me swear you, Mr. Bigelow, and please raise your right hand. Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise until the time in which verdicts have ended or deliberations have ended and a verdict has been rendered, so help you God? Thank you. All rise for the jury. Oh, sorry. Somebody gets to go home. Juror number 7, you get to go home. Thank you for your, oh, don't look that relieved. Don't do that. Thank you for your service. You want to stop by and see administration, and do they need to go get, oh, you already got it. All right.
Actually, no, they need to go get paid.
What time they have to get paid by? Oh, well, then they have an hour and 10 minutes to go and deliberate. Any matters while they are deliberating?
Nothing from the people, Your Honor.
Okay, we're in recess until the time that they have a verdict, but stay close. They may have a question, and actually you stay put because I have 2 other issues with your client. know.
Well, got the trial done quickly anyway.
We're not playing around.
Calvin's saying how he needs to keep his grades up, so he wants to get something and get good grades. We got the trial done as fast and judges keep pushing this. Get through.
Now on the trials done.
Like, 2.
And they gotta go downstairs and get their payment. Okay, you can be seated. Okay, did you choose a four-person? Very good, and you can give him the verdict form. You all have come to a verdict, correct?
Yes, we have.
Unanimously?
Yes, Your Honor.
Okay, please read your verdict.
We find the defendant not, sorry. We find the defendant not guilty of
Okay.
charges.
Do you want the jury polled?
No, thank you.
Okay, thank you, ladies and gentlemen, for your service today. This system in the criminal justice system does not it's not effective if you're not here to serve in this capacity. This is one of your most civic and fundamental duties as a citizen in the free world. And so we appreciate your willingness, your attentiveness in serving today. We do need to get you downstairs to the Treasury Department so they can give you your payment for today, and then you'll be free to go if you'd like to stand back after you get your payment to have discussion with either of the attorneys. That's completely up to you if you want to do that, or with myself. We'll be here, but thank you again for your service. All rise for the jury. Okay, that concludes this jury trial, and this matter is an acquittal by jury trial. We'll get you a form in just a moment, okay? Thank you.